So thank you everybody for coming along to this webinar today. My name is Tabitha, and I am a succession and tax solicitor at Thrings. We are joined, or the main host of the webinar is, as you can see on the screen there, is Polly Sweeney, and Polly is going to talk to us today about meeting the needs of vulnerable clients, which I think, given the year that I've certainly had, is more important than ever, and I think Polly's going to address some really key points for us. Polly, I don't know if you want to say anything just before we fully go into the webinar, or are you happy to start the ball rolling?
I'm happy to start if we have a good enough number who have already joined us.
Yeah, we're at about 40. So obviously, welcome to everyone. This is a Bristol Law Society webinar, so thank you for finding us and coming in there. It will be recorded, so if you want to check out Polly on YouTube afterwards, it will be on the Bristol Law Society YouTube page, and the slides will be circulated at the end. We will also be doing questions. We've had a couple come in and they're really fantastic questions, so if anyone wants to put them in, we'll be doing them at the end as well. If you can use the Q&A function at the bottom on Zoom, we will be looking at them then. We've got a couple lined up, but feel free to pop them in the box there. And if you want to know any more about the Bristol Law Society webinars that are upcoming, there are a few really good ones on there. Please check out our website, or you can email events@bristollawsociety.com, or you may well be in receipt of our Legal Life newsletter. So there's lots of upcoming webinars. I think I'm probably going to hand over to Polly now, but enjoy, guys, and I'll see you at the end for questions.
Brilliant. Thank you so much, Tabitha, and afternoon, everybody. Thank you for joining us. As Tabitha said, I am going to be doing about an hour's presentation today on meeting the needs of vulnerable clients, and then we'll have an opportunity for Q&A at the end. Just so you know, when I'm presenting, I can't see the Q&As that are coming up, so I will deal with them at the end, but I'm not ignoring you. So I'm giving this presentation, I guess, wearing two hats. First of all, as chair of the Law Society's Mental Health and Disability Committee, and as part of my role on the committee, we have produced some guidance for practitioners on working with vulnerable clients and clients that lack capacity. And so I'm going to be taking you through those. And also as a partner at Rook and Sweeney, where a large part of my practice is representing disabled clients, some who have capacity, some who lack capacity, and that is in a wide range of cases, including in the Court of Protection. I'm really mindful, though, that the attendees that are with us today come from a really wide-ranging background and different experiences of vulnerable clients. But I think that these issues are important for every solicitor and legal professional who works with clients. And it doesn't matter if you're a private client solicitor who is dealing with, wills and conveyancing and trusts, or a family lawyer, criminal lawyer, or a commercial lawyer who is doing banking. And in any part of your practice, you may encounter a client who at some stage may be vulnerable. That could be, for example, because there is a change in their health conditions. And so it's really important that everybody understands the obligations and the duties in those circumstances, and what you should be doing as a solicitor, not just to comply with your own duties and responsibilities, but also to make sure that we're offering the best service we can to our clients. So I thought I'd start off by looking at some resources which I think are just really important for you to have available when you are faced with difficult issues relating to vulnerable clients or clients lack capacity. The Law Society has produced a series of guidance notes, and I've put links in the slides that will be circulated later to those, so you have easy access to them. But there is, first of all, the main guidance, which is meeting the needs of vulnerable clients, which I'm going to look at today. With that are a number of case studies which I think are useful to have a look at. They cover varying different examples. For example, a client with learning disabilities, or a client who lacks capacity, a client who's subject to undue influence. Then there is some more detailed guidance about working with clients who might lack capacity. And then there is the financial abuse guidance note. And then there is some slightly older advice, but I think still really useful, about providing services to deaf and hard of hearing people. And then finally, there is the SRA guidance on reasonable adjustments in the provision of legal services, which I will also touch on briefly in the session. So I think the first thing that I would say when thinking about clients with vulnerabilities is to not make any assumptions at all, either as to the level of support that somebody will need, their capacity, or even whether or not they are going to require additional support. But some of our clients, whether because of illness or disability or diagnosis or their particular circumstances, may be vulnerable. And it's part of our duty as solicitors to make sure that our clients don't have barriers in accessing legal advice, and that they're given all possible support to be able to make decisions. So there are 3 types of vulnerability for our clients, and I think it's really important that you know which type you're in when you're thinking about the type of support that you need to provide. So first of all, you will have clients who have capacity to make decisions and give you instructions, but they might need extra support to do this because of their mental or physical disabilities. The second type is clients who lack mental capacity to make decisions to provide you with instructions. And in those circumstances, you must follow a specific route for those clients. And then thirdly, you will have a category of clients who are vulnerable, but they are subject to undue influence, or at least vulnerable to undue influence, undue pressure or duress. And this group may or may not have mental capacity to provide you with instructions, but they are, in addition, vulnerable to undue influence. So I suppose just pausing here, why is this important? Well, if it needs to be said, if a court finds, I think one of the most important things to keep in mind is that if a court finds that a client lacked capacity to enter into a transaction, or the transaction was made through the undue influence of another, that transaction will be set aside. And there is lots of case law which shows this happening in practice in relation to commercial transactions, in relation to settlement agreements, that if at a later date it transpires the client didn't have capacity, then that transaction will be set aside. There are also particular regulatory and legal considerations that as a solicitor or as a firm of solicitors you need to keep in mind. So for example, you could face a discrimination claim or a claim for failure to make reasonable adjustments under the Equality Act, which could result in sanctions and including damages. You could face a claim for damages or compensation against you or your firm if you act on your client's instructions when they didn't have capacity, or you hadn't taken appropriate steps to satisfy yourselves about client's capacity. You may face a complaint against you to the legal ombudsman, a complaint to the SRA, and of course reputational risk as well in relation to how you treat your clients and how you treat their liabilities to other parties. Those are the risks, but of course there is also a positive to this, and that a more inclusive practice is going to attract more clients, a more diverse workforce, and bring lots of benefits to the business. So how do we identify vulnerable clients? Well, I've taken from the Law Society's guidance note a number of indicators, and again, it's really important not to make assumptions, but these are considered to be risk factors where you might need to think about providing your client with additional support. So things like advanced age, physical disabilities, ill health, learning disabilities, experiences of domestic violence or sexual abuse, long-term alcohol or drug abuse, dependence on a care provider. I won't go through them all because they're listed there, but you can see there are a number of risk factors. So if you have a new client or an existing client who presents with one to a number of these risk factors, that might mean that your client is vulnerable and may need additional support to be able to express their wishes, understand the advice and give you instructions. Or it might mean that they actually lack mental capacity to give you instructions. Some signs are going to be easier to spot, sometimes it's going to be more subtle. And I think just don't hold back from asking for more information from clients. And clients are often very happy to be open about their difficulties and discuss. And so, what we do at our firm is that we make sure that we ask that question in our initial client retainer and ask the client to tell us. We also, when we have our initial telephone conversations with our clients, our initial meetings, we make sure that we ask about whether there are any difficulties or any factors that we need to take into account. And we have a conversation at a very, very early stage in the retainer about how best we can support the client with their particular needs. I think once you then identify risk factors, the next stage in the process is identifying your client's particular needs. And as I said, that really should involve an early discussion with clients right at the initial retainer stage, trying to find out whether your client has got any needs or preferences for communicating, whether they need any help to access our services, for example, mobility problems or hearing or sight difficulties, whether they have any particular needs about how services are provided. For example, documents needing to be written in a clear and simple language, or for information to be provided verbally as well as in writing. And to try and ascertain whether your client understands and can act on the information advice and whether they need any additional support to do that, for example, from an advocacy service or from an interpreter or a family member. Carers and family members can often, I think, provide helpful information, but it is really important that you try to discuss these matters with the client alone as well. And I will come on to talk about undue influence later on, but it's really important that we know that these are our client's instructions. And sometimes carers or family members can have particularly strong views, and it's important that we check that they also reflect the views of clients. And from my own practice working with lots of vulnerable clients, I understand this can be difficult for clients because coming to see a lawyer for the first time can be pretty daunting for any of us, frankly. And so saying, well, look, from our first meeting, we must meet you alone. A lot of vulnerable clients might not feel comfortable with that. So I take a view that you have to look at each case individually. And sometimes I might say, well, it's fine for you to have a family member or carer with you for the first part of the meeting, but then I'd really like, when you feel comfortable, I'd really like to be able to speak to you on your own afterwards, or arrange a separate meeting once you've established that relationship with your client and they feel comfortable meeting with you, to be able to see them alone. I think the principle that we need to be guided by always when thinking about this is that we need to support our clients to make decisions that they're legally capable of of doing. And so not jumping too quickly to finding a client doesn't have capacity or you can't take their instructions, but looking to provide all possible support to enable clients to make those decisions for themselves before we reach that point. There are also many things that we can do to support and enable vulnerable clients to use our services. And that includes our marketing materials and the language that we're using in our marketing, and the way that our marketing is showing that we're supporting a diverse range of clients. Secondly, our website accessibility. There is a huge amount that can be done with IT now to be making sure that websites are accessible, not just in terms of the language that is used, but the ability to read materials via audio, making sure that you've got clear descriptors on difficult terminology on your website, and that it's possible to change the background and the size of the font. So all of those things are really important to think about. So when clients having that very first contact with a law firm, they can see straight away that this is an accessible law firm. And then thinking about accessibility, getting to our premises and then around our premises. And so making sure that there has been clear risk assessments about accessibility and lift access and access for wheelchairs. That's really, really important. And doing that in a proactive way, so not waiting for a client who has accessibility needs to come to us for that to be the first time that we're thinking about these things, but so that we feel confident in advance that any client can walk through our doors and that our premises are going to be suitable to meet their needs. The other thing to think about is staff training. So for all staff who are going to be having any contact with clients, that's not just qualified lawyers, but that is reception staff, security, staff who are answering telephones and secretarial support, making sure that they have appropriate training to be able to understand, so disability awareness training, understanding the duties to make reasonable adjustments, quality training. That's really important for all staff in making sure that our vulnerable clients can be supported to use our services. The other thing to think about is appointments and where those appointments take place to provide the best environment in which a client is going to feel comfortable providing instructions. That's not always going to be our offices. And sometimes it might be necessary to go and visit our clients in their own homes or in hospital or in care homes if that's where they're living. And so with appointments, it's really important to be thinking about even just simple things like the time of day of the appointment. So, for example, if you have a client with dementia, there may be certain times of the day where they are more alert and more able to engage and give you instructions. And so you can speak to those who support them and know them well and speak to the person directly to find out if there's a good time of day for the appointment. Thinking about how long that appointment should be and whether actually you need to do a series of appointments to cover the information and having clear breaks during those sessions. And then with all home visits, I think another important thing to think about is doing the assessment for you as a solicitor or the member of staff who is going out to visit a vulnerable client. And thinking about, well, have we seen this person before in their own home? Are there any particular risk factors that we need to think about to ensure safety of those home visits? Should we be sending a second person who should be going with them? There is some great information by the Susie Lampley Trust. And I know from my own experience as a solicitor that they provide great training as well in how to look at some of these. But I think all firms as a minimum need to have a policy for how they manage home visits and visiting clients in their homes, both so the needs of the client can be met, but also the staff themselves. Then thinking about written communications, there are many, many ways that we can tailor our written communications to meet the needs of our client. And they can be simple things, just like the size of the font on a letter, or the colour of paper that's being used, and of course the language, and trying as far as possible that you're not using any jargon, that your language is clear. I know that's a challenge for us as lawyers. It's not something that all of us are particularly good at. I think I'm definitely guilty of that. Another thing that I appreciate, this might not be possible for all firms, but certainly for larger firms, thinking about if some of your key written material as a firm can be provided in an easy read format. And there are a number of charities, for example, MenCap, who can support organisations in producing easy read versions of their materials. So that might just be key documents that you have, like your retainer letter or your complaints policy, but it really goes a long way, I think, in being able to support our clients in using our services. Then thinking about court hearings. So if you have a court hearing, your client is coming along, doing kind of a walkthrough in your head of what that experience is going to be, not for you, but for your client, from where they're going to park, how they're going to get into the court building, how they're going to find their way to the court hearing room, whether you need to alert the court to put in place particular arrangements. I'll talk a little bit more about court proceedings or court hearings later on, but really thinking about all of this from the perspective of our client and their particular needs. Thinking about also whether you need to engage specialist support, for example, from an independent advocate. And again, I'll talk about that a little bit later on. And then making sure that all communications at every stage are tailored and appropriate to your client, and making sure that you make reasonable adjustments. So looking at reasonable adjustments, these are, of course, it's not just good practice. This is required as a matter of law to discharge duties under the Equality Act to our clients who are disabled. There are many, many ways that you can make reasonable adjustments, and it's important to be thinking about the individual needs of your client. But I've set out here some examples of the sorts of things that you could be thinking about to discharge your reasonable adjustments duty and to be making sure our clients are properly supported. So they can range from things like allowing extra time for a meeting for a client who might need longer to understand things, or if you're communicating through a third party or an interpreter. For those of us who work with interpreters, it can often double the length of your meeting if you need an interpreter, and it's really important that this isn't rushed, and so you need to make sure that you've given enough time in your diary, making sure the client is in a place they feel most comfortable. Breaking down the interview into many parts, allowing rest breaks, arranging meeting for an appropriate time of day. That's again, as I've mentioned before, really important for certain clients in particular. Providing information in large print, in braille, audio, infographics, simple drawings by hand. I think sometimes as solicitors we can be nervous about how creative we are with this, but some of my clients have really appreciated me going online and getting some photos of the court building, emailing the court and asking for a copy of a photograph of the judge, and putting it all together, a photograph of me, a photograph of what my firm looks like, and putting all of that together into a document to send to the client can really help them to be involved in the process. I said things like facilitating a sign language interpreter or a deaf-blind communicator, perhaps this might not be possible for smaller firms, but certainly in larger firms, installing an induction loop or having a portable one available. There are so many ways that we can make reasonable adjustments. And of course, whether an adjustment is reasonable, as a firm, we are allowed to take into account the cost of that, and what might be reasonable for a very large firm might not be possible for a much smaller firm. But it is really important that we do all we can to support our clients with these things. So I mentioned about court hearings and ways in which we can support our clients in attending court. And this very much varies dependent on the type of proceedings that we have. But I set out here what I think are 3 brilliant examples, or certainly 2 of them, which I'm familiar with, really good examples of resources that you can use. So first of all, in relation to criminal cases, there is the Advocates Gateway Toolkits. And actually, these aren't just useful for criminal cases. I use them in supporting my clients in court of protection work. And there is a brilliant resource in setting out all of the support that a client might need in attending court. And and that's looking at different clients with different needs. And so I would definitely make sure that you're familiar with those, and also that your counsel is, if you've instructed counsel in the case, that they're familiar with those as well. In family law cases, there is the practice direction, which is a vulnerable person's participating in proceedings and giving evidence. I'm not a family law practitioner, so that one isn't quite as familiar to me, but the one that I am familiar with is the Court of Protection Guidance, which is facilitating the participation of P and vulnerable persons in court of protection proceedings. And this was a guidance note that was produced by the court following a particular court of protection case, in which was seen as a very good example of best practice in supporting P, so our client who lacks capacity in those proceedings, to participate. And it's looking at all the things that I spoke to you about earlier in relation to court hearings, and in particular thinking about the use, for example, of an intermediary to support the client when they're attending court, to make sure that they understand the process and what's happening, and that adjustments are made. I have many clients who lack capacity to instruct me and have a litigation friend, but they still attend court and they still want to attend the court hearings, and they want to be involved in the process. And certainly in the Court of Protection, there's so many ways that the court can support that. You know, I have cases where the judge has been happy to meet with my client before any of the other advocates and parties arrive, so that I can show them around the court, show them where everybody's going to be sitting. They can meet the judge perhaps in chambers, so that they can be familiar with the judge beforehand and even have the opportunity to speak to them, so they can feel at ease, and then they can sit at the back of the court, but also be free to get up and leave whenever they want to and come back in again. You know, I even had a case where a judge made biscuits for my client because they knew they were coming to court. And there really is so much that can be done if it's properly planned and thought about to support participation in proceedings. Carers, and I include family members in this, as well as professional carers, often can really help in communicating and helping us to identify what reasonable adjustments can be made, and to assist the client in instructing us. It's really important, as I said, that you keep in mind the principle of client confidentiality and needing consent if confidentiality is waived before you start discussing these things with carers or with family members. And it's really important that you keep in mind all the time who your client is. And that if you are speaking to a relative or a parent or a carer, that it's only the client that can give you instructions and no one else is able to do that. It is fine, and I have many cases where clients, say for example a young person who has capacity but needs some extra support in providing instructions, they will provide written authority for me to be able to speak to their parent and take instructions on their behalf from their parent. And I'll make sure that I have a conversation with that client directly, make sure they understand what that means, and I'm happy that they understand the authority that they're providing. But I also, whenever big decisions are being made on the case, I don't just rely on speaking to that carer or family member. I always make sure that I take the instructions directly from the client themselves as well. So I've started off by talking about clients who are vulnerable for many, many different reasons. But just being vulnerable doesn't mean that the client can't instruct you and that they don't have capacity. But there may be some clients whose vulnerabilities mean that they lack the mental capacity, they lack legal capacity to be able to give you instructions. And it's important that you are alive to this, not just at the start of retainers, but all the way through the life of your retainer. And you could have had clients that you've acted for 10 years perhaps, and there may be changes that mean you have to consider whether they have capacity. So first of all, I suppose as a reminder, the SRA's Code of Conduct for Solicitors requires us to take into account our client's attributes, needs and circumstances, and that if we have any doubts about whether our client has capacity to give us instructions, that we are making sure that we satisfy ourselves about capacity. And capacity is, of course, decision specific. And so a client might have capacity to make certain types of decisions, but not others. And that can include legal decisions as well. A client might have capacity to grant a power of attorney, but they might not have capacity to make a complex decision about personal injury litigation. And so it's important to think about the particular decision that the client is being asked to make and whether they have capacity to do that. Capacity is also, so there's capacity to instruct a solicitor, and then there is capacity to make decisions about the subject matter. And they are also two separate tests as well. So as I said, if you have reasonable doubt about your client's capacity to give proper instructions, it's then your professional duty to satisfy yourself about that. So the test for capacity and the starting point comes from the Mental Capacity Act. And I think that probably many of you joining this will be familiar with the statutory principles. But for those that aren't, because they're so important, I'm just going to remind us all that the Mental Capacity Act has a number of, so it has 4 guiding principles that underpin decision making and starting point for assessing capacity. So the first is that there is an assumption of capacity. So we start off on the presumption that our clients do have capacity to make these decisions. A person is not to be treated as unable to make a decision unless all practical steps to help them to do so have been taken without success. Thirdly, a person is not to be treated as unable to make a decision simply because they make an unwise decision. So even if we very, very strongly disagree with our client's instructions and we think that it is very, very unwise, that in of itself doesn't mean that they lack capacity. It might give you reason to consider the matter further, but in of itself doesn't mean that your client would lack capacity. So the starting point is that there is a presumption that client has capacity, and then where there is doubt, the burden of proof is on the person seeking to establish a lack of capacity on the balance of probabilities. So you're not required to be sure, but just on the balance of probability. So more likely than not, does my client lack capacity? So what is the test then? As I said before, capacity is both time specific and decision specific, and the capacity will vary dependent on the decision being made and the time it's being made and the circumstance of the person. You can't establish a lack of capacity simply because of a person's age, appearance, condition, or any aspect of their behaviour. So I have had, over the course of my career, occasion where I have had somebody say to me, this person doesn't have capacity because they have a learning disability or because they have dementia. That isn't enough. That just having a diagnosis or condition doesn't mean that somebody automatically lacks capacity. So you have to apply, first of all, the test set out in Section 2 of the Mental Capacity Act, which provides that a person lacks capacity to make a decision if they cannot do one of 4 things. So first of all, they can't understand the information relevant to the decision. They can't retain that information. Now, on retaining the information, that is only retaining for a period as long as necessary to make a decision. And sometimes that can be a relatively brief period of time. Thirdly, that they cannot use or weigh the information. They cannot use or weigh the information as part of the decision-making progress or communicate that decision by any means. So communicating a decision doesn't necessarily mean that your client is able to verbally communicate. I have had a client many years ago who was able to communicate very well using eye gaze technology. And so it's important not to make any assumptions about communication where the client has difficulties communicating verbally. And so it's not just that the person cannot do one of those three things. There is a second part of the test, which is that the inability to do it is because of an impairment or a disturbance in the functioning in the person's mind or brain. So that is often known as the diagnostic element of the test. So you need to have both for a lack of capacity. First of all, an impairment or disturbance of the functioning mind, person's mind or brain, and then secondly, that as a result of that, the client cannot do one of those three things. And so in terms of what is the information that our client is going to need to be able to understand, to be able to retain, to be able to weigh up, well, that's going to depend on the particular circumstances of your case, and that information is going to differ. And you're not going to expect your client to be able to understand and weigh up information about their finances if actually the instructions relate to a matter of their welfare. So it is all going to turn on the particular transaction that you're instructed to deal with. So as I said before, capacity is decision specific, and one of the decisions, the first decision for you when a client is instructing you, is whether they have capacity to instruct a solicitor. And you need to be satisfied that your client has capacity to give you instructions. And if you have any doubt, the first thing that you need to do is a capacity assessment. And different levels of capacity are going to be needed, as I said. And so you've got to assess your client's understanding in the context of that particular transaction. And there are specific legal tests for different types. So generally speaking, the test is the Mental Capacity Act, and that I just took you to in section 2. But from common law, we have some additional tests that we have to fit into the Mental Capacity Act test. So there's a specific legal test for making a will. There is a specific legal test for making a lifetime gift. I am not a practitioner that practices in those areas, so I'm not going to even attempt to cover those. But what I will do is cover the legal test for conducting civil litigation or civil proceedings, because that is the one that I consider most routinely when a client comes to me wanting to pursue a matter in trying to be satisfied that they have capacity to give me instructions. So there was a Supreme Court case in 2014, Dunhill and Bergen, which had confirmed the principles for capacity to conduct proceedings, and that you start off with the principle from a very well-known case of Master and Lister, and essentially that a party to legal proceedings is capable of understanding, with the assistance of proper explanation in broad and simple language, the matters on which their consent or decision was likely to be necessary in the course of proceedings. So that test is applied to proceedings as a whole and not at each step. And so the things that you need to think about is whether the client can understand how the proceedings are going to be funded, the chances of not succeeding and the risks of having to pay costs, to make the sorts of decisions that are likely to arise in the litigation, and to give proper instructions for and approve the particulars of claim and a compromise settlement. So how do you assess capacity? Well, the first thing to say here, and I think sometimes this is missed, is that it is for us as the solicitor to decide whether our client has capacity to instruct us. I'm going to talk about using experts to assess capacity, but we cannot delegate that decision entirely to an expert. We have to do our own assessment and be satisfied for ourselves of the position on capacity. And a medical view is just one part of the information that we draw on to reach that view. So it's our responsibility to identify what the client needs to understand in order to instruct us, and the support that the client needs for decision making, and record in writing that assessment of capacity. Now, I would always suggest that when you are doing an assessment of your client's capacity to instruct you, that you include verbatim answers to questions, so that if there is a dispute about whether your client did have capacity or not, you can refer to the contemporaneous notes. And of course, this is really important, because if a client reaches a settlement agreement or enters into a transaction, and at a later date somebody says they didn't have capacity to do that, and you'd decided they did, you're going to want to be able to refer to these contemporaneous notes to show how you thought about all of this. If you, though, do your initial assessment, sometimes it's really obvious, for example, that you're completely satisfied that your client has capacity, and yes, they do need additional support in particular areas, but they're well able to give you instructions. Or secondly, it's just very, very clear to you that they don't have capacity, then you can form that view yourself, and you don't have to have an expert that confirms that. But where you aren't sure and you're not confident in your own view, then you may want to seek the opinion of an appropriately qualified professional. And so and sometimes you might have to have that assessment. For example, if it relates to an application to the Court of Protection, and you have to complete a form called a COP3, then you have to have a medical opinion. It's not enough what the solicitor says often. So you need to think about, where you can get this information from and where you can get this capacity assessment from. And the client might actually have had contact with local authority social services departments who've already completed a capacity assessment on the particular issue. And so it's definitely worth contacting the local authority, obviously with the client's consent where they're able to provide it, or if it's in their best interest where they lack capacity. And the local authority should share that with you free of charge. And I think that provides a good reference point, a good starting point in deciding whether you're going to need to then get a further professional opinion. And again, you can't just say, well, I've got that document from the local authority, I don't need to turn my mind to it. It's really important that you also think about this for yourself. And ultimately, if there is any dispute, it is for the court to decide whether or not a client does or doesn't have capacity. And I set out there again a reference to Master and Lister case that we all know. So techniques for assessing capacity. I think certainly some of my colleagues who I speak to are sometimes nervous of assessing capacity because it's something that we just so often just defer to an expert for their medical view. But it is something that we're well able to do for ourselves. We don't need to always be asking a medical professional to do, or an expert to do this for us. So some tips in terms of assessing capacity, thinking about how and when you see your client is really important. Somebody's capacity could change quite significantly over the course of a day, and choosing the right time of day and where they feel most comfortable. And the first thing is just not to jump straight into starting to do your capacity assessment, making sure that you put your client at ease first, having a chat about other matters. I always find it's helpful to understand a bit about my client's wider background and career, and things that you can talk about. So perhaps if they have hobbies or things that they enjoy, you can be building a bit of rapport first. And then you want to get some useful information so you can verify things as well. So if your client says, if you're taking instructions on whether your client has got capacity to enter into divorce, and your client says that they have assets of £20 million, you need to know, does your client have £20 million, or in fact, are they receiving welfare benefits? That might be relevant then to your determination of capacity. And you could also ask some questions about current affairs and past events. As I said, make very detailed response or detailed notes of the assessment. And then when you have any subsequent interviews with your client, you should discuss the matters again and check what the client says and making sure that there's consistency in the instructions that you're being provided with. And sometimes if you are getting materially different instructions on different occasions, or it appears that your client isn't retaining things in a way which is necessary, that might indicate that you need to revisit your capacity assessment, and that they might lack capacity, going back to that test that I set out under the Mental Capacity Act. And of course, remembering that you're testing your client's capacity of understanding their decision, understanding the decision to be made, and not whether you agree with it or not, because we mustn't kind of impart our own value judgments when we're deciding whether somebody's got capacity, because what we feel might be important might not necessarily be the same things that our clients feel important. So we have to be really subjective at all times. You should try and make sure that you do the capacity assessment without the presence of anybody who has an interest in the outcome. And that's particularly, I think, important because when you are doing capacity assessments with family members present, because naturally, often family members want to jump in and help the client answer the questions, and it's really important that the client themselves answers these things. When you do the assessment of capacity, you need to know what the relevant information is that you're expecting your client to be able to understand and weigh up, and be making sure that somebody's actually discussed that with the client for the first time. And this isn't the first time, sorry, that this has been raised with them. You know, I have been involved in cases where issues have arisen about whether my client has capacity to consent to sexual relations. And one of the features of the test is whether they can understand that there is a risk of sexually transmitted infections. And I have seen, though, capacity assessments where somebody will say to my clients, okay, tell me what are the risks of having sex, and do you know what STIs are? And my client will have no idea, but no one has ever told my client that before. A little bit of support, my client was well able to understand these concepts, and that was really important, because that was the difference between my client being able to have capacity to make a really important decision and being found that they didn't have capacity, which means they wouldn't be able to do it. So knowing what the relevant information is really, really important for any decisions that you're making. As I said, though, sometimes, and it's completely fine if you don't feel confident in reaching your own view on capacity, that you want to get an expert opinion to help inform you. And you can't just defer to them completely. This is just a piece of information to help you. But the first thing that you should do, if you have a client where you think, I'm not sure if my client has capacity, and I've spoken to them a few times now, and I'm just not sure, I've tried to assess this myself. The first thing you need to do is to make sure that you have the client's written consent that they are happy to be assessed. And you are going to need to explain to the client what the purpose of the assessment is and why it's necessary, and what will happen if you don't do that assessment. Then you're going to need to find a suitable professional who's willing and skilled to do the assessment, and that's not necessarily always going to be a medical professional. That could be a social worker or a speech and language therapist. It could be the client's GP, or dependent on the extent to which this might be contested and how important this is, you might want to instruct an independent expert, a neuropsychologist or a psychologist or a psychiatrist, to be able to do this assessment for you. You might have experts already involved in the case. For example, if it's personal injury litigation, you might already have a neuropsychologist or a psychiatrist involved who you could ask to assist with this assessment. You need to make sure then that when you instruct the expert, you aren't just sending it an instruction which says, tell me whether my client's got capacity. You need to set out the purpose of the assessment, the legal test that needs to be applied, what concerns you had that led you to have reason to believe the client might lack capacity. And then what test, as I said, what test the expert should apply, and then what the relevant information is that the expert needs to be aware of to be able to do the assessment. They can't just do this on a blank canvas. So for example, if you're asking an expert to decide on whether your client has capacity to give instructions on a will, they need to have information about that client's financial position. It shouldn't just be, as I said, a blank canvas. One of the most difficult circumstances that I come across, though, is where you're not sure if your client has capacity, and you don't feel confident about this, and you think, I'm really not sure here, but your client is objecting to having the assessment. And I've come across this on a number of occasions, and they are really, really tricky cases. The first thing is that you should try and take all reasonable steps to encourage your client to get the report, and how important that is. And that if they refuse, you need to explain to your client in writing as well that you're unable to act for them or continue to act for them without a report. That's how serious it is in being clear on capacity. And so it's really important your client engages in that assessment. If you must also explain to the client the potential legal consequences of that, so that if they enter into a transaction or agree a settlement, and it later comes to light that the client didn't have capacity, that could be open to challenge and being set aside. So it's in your client's interests that there is clarity over this. Sometimes if proceedings are being contemplated, so you'll know you're going to be issuing proceedings, or proceedings have already been issued, you can apply to the court for a determination on whether the client lacks capacity to conduct the proceedings. And the court can then order that an assessment takes place. So the court have no power to order that the client must engage in that assessment. And so the client could still refuse to undergo a medical assessment. And in those circumstances, the best that we can do, the best that the court can do, is make a decision without the benefit of any external expertise, based on all of the information that they have available. The courts have emphasised that judges should be really slow to do that because of the serious consequence of that person. Taking away somebody's legal capacity has significant implications on their human rights, and so it really, really should be only done where there is clear evidence. But sometimes you don't have all the evidence that you want, and you have to decide it on the best information available. And that's when I think the court really needs to be involved. And so they can take some of that weight of responsibility off of you as well as the solicitor in having to make that difficult call. So what happens if your client does lack capacity? So either you're very clear yourself your client has lost capacity, and you don't need a professional report to inform that view, or you instruct an expert and they tell you, yes, I do think your client lacks capacity to give you instructions. Well, this may give rise to circumstances where you can decline to continue to act. And indeed, generally, so the SRA and the Law Society's position is that, as a matter of law, as when a client loses capacity, that will automatically terminate the retainer that you have in place. So your retainer will no longer be valid. There are exceptions to this rule. For example, sometimes retainers make provision for potential loss of capacity. Often they don't, though. And so you need to be very aware that from the point you're put on notice that your client lacks capacity, your retainer is no longer valid. So you need to either end your retainer, or if you do want to keep acting for the client, you must make sure that you identify an alternative person who does have authority to give you instructions. And so and you do have an ongoing duty to act for your client, or an ongoing duty to your client in these circumstances. And I would suggest that you need to go as far as practically possible to take action to protect your client's interests. And that might include trying to identify somebody who give you instructions. So I had a case very recently where my client had been giving me instructions for a few months, but I became increasingly concerned about their capacity on a community care matter, about their social care needs. In the end, I formed the view that they didn't have capacity to instruct me. I tried to see if there was a family member suitable who could give me instructions on their behalf. There was no deputy, there was no attorney, and the family member that I was in contact with, I formed the view there was a conflict. So where you can't find anybody else, the official solicitor, who is a government appointed role, acts as litigation friend as last resort in those circumstances, and can step in and act as litigation friend where there's nobody else. So where there is no current proceedings though, so in proceedings, the court can appoint a litigation friend. Outside of proceedings, but where proceedings are contemplated, you can identify a third party to act as a proposed litigation friend. There isn't any neat guidance or law which says what the status of proposed litigation friend, but it is an established practice that you can take instructions from a proposed litigation friend. And indeed, the legal aid rules say that a proposed litigation friend can sign a legal aid application on behalf of a client. So thinking about who, there are a number of people who could act as a litigation friend. That could be a family member, a friend, another professional, an advocate perhaps, and as a last resort, the official solicitor. There may, though, litigation friend is only one way in which you can receive instructions from somebody who lacks capacity. And you can be instructed sometimes by somebody in the role of agent if somebody lacks capacity, and that is most commonly where somebody has an attorney or a deputy and it's within the scope of their authority. And so if a person has an attorney or a deputy, then the person themselves is still our client. So you must remember that, and that you must always act in your client's best interests. And if you're worried that your agent's instructions aren't in our client's best interests, then you may need to decline to continue to act, and a conflict may arise between the two. So there are circumstances, though, where you might be deemed to be acting for the agent rather than the person themselves, and I've listed there the circumstances where that happens. So agents, they can act, they're not a litigation friend, but they're acting as agents. So for example, a court of protection, a property and affairs deputy might appoint a conveyancing solicitor to deal with a property transaction. They're not doing that as a litigation friend, they're doing that as agent. So that's another way in which instructions can be taken. I've set out there a little bit more about the role of attorneys and deputies. I think just as a reminder, they can't automatically act as litigation friends and pursue litigation for clients who lack capacity. And there was a judgment handed down last year by Senior Judge Hilda in the Court of Protection called Re-ACC, which sets out and reminds us of the limits on a deputy's authority to embark on litigation on a client's behalf, and the need to make sure that they have authority to do that. The Law Society is just finalising some guidance on this, which I hope will be published in the next couple of days, to help practitioners, in particular deputies, work through that judgment and what that means in terms of acting for clients that lack capacity. And so that's something certainly to keep in mind. Just a little bit more about litigation friends. As I said, where an individual lacks capacity to conduct proceedings, a litigation friend is appointed to give instructions and otherwise conduct the proceedings on their behalf. And the guidance is in part 21 of the CPR about how a litigation friend can be appointed. And within court proceedings, the need to have a certificate of suitability. And so there is within the context of court proceedings, there's a specific process by which litigation friends are appointed. So I've talked about the first two types of vulnerability. I've talked about clients who have capacity but are otherwise vulnerable. And I have talked about clients who may or do lack capacity. The third category of cases, which I will just mention briefly before I move on to questions, is influence and undue influence. So some people might not be able to make decisions, not because of an impairment or disturbance in their mind or brain, but because of the influence of others, such as family members. And the law treats this group of people differently from those who lack capacity under the Mental Capacity Act, because they have capacity. Nobody else can make a decision on their behalf. And so in these cases where somebody can't make a decision because of the undue influence of others, the High Court can use its jurisdiction in relation to vulnerable adults where they have reason to believe that the person is under constraint or is subject to coercion or undue influence, or for some other reason deprived of the capacity to make that decision for themselves, or is unable to give real or genuine consent. And in these cases, the role of the court is not to take over as decision maker, but to try and remove that undue influence to enable that person to make that decision for themselves. And this can happen in a range of different jurisdictions, but there is a remedy available. Unfortunately, it doesn't have any statutory underpinning, and I think that's a real gap that we have in our legal system at the moment, is a statutory basis for supporting vulnerable people subject to undue influence. But the High Court can use its jurisdiction, exercise its jurisdiction in respect of these individuals. So as solicitors, what should we be doing? How can we assess whether there is undue influence? Well, in your first meeting, often information will come from an intermediary, such as a family member or carer or concerned neighbour. In most cases, these people are going to be well-intentioned and will be communicating with the client or on the client's behalf with their consent. But I think you must always be alive to the possibility of conflict of interest and undue influence, and that your overriding duty is to your client, and that regardless of the views of the family, is that you need to be making sure that your instructions are coming from your client free of undue influence, and that if your client has got capacity to do so, you need to confirm your instructions directly with the client, seeing them on their own without that third party present. And so if you have any suspicions that your client's instructions are as the result of coercion or pressure, you cannot act unless and until you're satisfied that your instructions are solely from your client's wishes. And then just to mention briefly, there are certain cases or certain situations where undue influence is presumed, and that's specifically in relation to making gifts. I've set out there a little bit of information. I won't go into it now because of timing, but if you're involved in private client work, I'm sure this is stuff which is really familiar to you already, but just to, I suppose for completeness, I wanted to just flag the situations where there may be presumed undue influence. Finally, if you are concerned that there is undue influence, making sure that when you do see your client alone, that you keep a really careful record and that you probe them for the reasons for their decision, trying to find out the driver for it and trying to understand what's influencing your client. And again, keeping a detailed note of the discussion. So I've also put here sources of information advice. So sometimes, more often than not, you'll be able to work through all of that as a solicitor, but sometimes you will have really tricky cases where you work through all of the guidance and you're still not sure. And I've been in that situation myself. In fact, very recently, I worked through the guidance and I still wasn't sure what I should do with a client who I thought lacked capacity, and I couldn't find a litigation friend to act for them. And I was worried about ending my retainer in those circumstances. There are two sources of information advice that you can use. First of all is the Law Society's practical advice service. It's telephone and email advice service on a wide range of matters. In fact, that is what I used in that case. I telephoned, despite all of the work that I do, I telephoned the service and said, I just want to talk this through with you and check that I'm complying with all of my duties. And there's also the SRA Professional Ethics Helpline as well, so they can help you making sure that you are complying with your professional obligations when you're working through some of these tricky issues. So do use those resources. They're available for us as part of our being members of the Law Society and regulated sector. Okay, so that was in an hour kind of taking you through the key areas of acting for vulnerable clients. I appreciate I can't really do it a huge amount of justice now, but I hope it's been helpful. And I might just now hand back to Tabitha to see if there are any questions that people wanted to ask. Thank you.
Thank you, Polly. That was really helpful, and just actually, I think it's really good to sit down and focus the mind on thinking about some of those points that you raised. We've had some questions come in, so I'll just start with the first one that's come in, and it says, what signs should I be looking out for when speaking to a prospective client for the first time on the phone?
I think that you should start off with those risk factors that I took you to right at the beginning. So when you're taking instructions, thinking about whether any of those risk factors are there, and to be exploring the issues with your client in the way that you normally would, but looking for factors which might suggest that your client is vulnerable or lack capacity. Doing this by telephone is really tricky though, and I think that very often I'll quickly conclude I can't do this by telephone. And in COVID times, I will revert to our usual, which is a Zoom or a Teams, first of all, and I'll see if that is better and that I'm able to get a better idea. But sometimes, I've had this recently where I was arranging a health and welfare power of attorney, is that I did telephone, I did Zoom, I still wasn't sure. And so actually I took the decision, and this is consistent with the Law Society guidance, we waited 3 or 4 months for the restrictions to ease, because it wasn't urgent at that point, but actually we've gone on so long now that actually the client really needed to have this power of attorney in place. And so the client, I agree with the client that once they had their vaccination, I'd actually go out and visit them in person at their home. And so it's still possible. We should still be seeing clients where that's needed, and many vulnerable clients are still going to need face-to-face assessments or face-to-face visits in these cases. Make sure you do a risk assessment, making sure your client understands the risks, which again is difficult sometimes if with vulnerable clients. But in that case, there's many things. The client had a vaccination. I made sure that in the week leading up to it, I was particularly careful with my exposure and going outdoors, so I wasn't exposing the client to any risk, and that we did the meeting in the client's garden rather than indoors. And so sometimes though, actually you need to do these face-to-face visits, and that's still okay where that's essential.
Yeah, COVID has definitely made dealing with vulnerable clients particularly difficult. And actually the second question that's come in sort of, I suppose, flows on from that, given that we're all working via Zoom and remotely. And this one is, how can vulnerable clients best be supported when accessing services remotely?
I think it's a really good question. And I think it's one that we've all had to think about really carefully, as you say, over the last year. And we're getting better at it. And I think hopefully we can take a lot of this into our practice going forwards as well. I know actually some of my clients have preferred remote and virtual. A number of my clients who've got sensory needs or autism, actually being sat in a room with them was really challenging for them. Doing it on a video where they're sat in a really comfortable, familiar environment, so I'm not sat there with them, and they've not had to engage in eye contact with me, for example, they've really helped them engage and to participate. I think another benefit of doing things remotely is that we have to prepare more. I think that's good for us, because we can't just turn up to a client at their home and just do the attendance. We have to really prepare beforehand. And so the sorts of things that I might do is to speak to the people who support that person maybe, and prepare in advance the questions that I'm going to be covering and send them over in advance, so that my client can be thinking about those questions before, and then testing if you're using a virtual link, testing that, and having maybe the day before coming online and spending 5 minutes and saying, can you hear me? Is this all okay? Is it working? Great, come off the line, let's do that again tomorrow. Preparation really, really is key to making this work. But I think also we must be alive to the cases where working remotely doesn't meet the needs of your client, and that we are going to need sometimes to be able to offer face-to-face. And of course, if a solicitor is vulnerable or in an at-risk category, you might not be able to do that, but you must then be prepared to pass that client on to somebody who can, to be making sure that they are able to engage in the service and give you the instructions that you need.
Yeah, no, I think that's a really helpful view on that one. I am conscious of time, but I'll go. I've got another question here. It says, any helpful initial tips for cases where you have doubts as to the other side's capacity, where both represented and unrepresented?
So I think the first thing to think about is our obligations as solicitors. So the SRA have produced guidance on balancing duties and litigation. So we need to be making sure that we're not taking advantage of any vulnerability of the other side. That's really, really important. And I think that in cases where you're genuinely, first of all, if the person is represented, you need to be raising those concerns with their solicitor. That solicitor has got their own professional obligations that they need to be complying with, and you would hope that they would be following that. And they would be discharging their duties to their client and doing the right thing. Where a client is unrepresented, or sorry, another party is unrepresented, and you have concerns that they lack capacity, I think you should be raising that with the court and bringing that to the court's attention, and inviting the court to decide how they want to deal with that. There's also, I don't think there's anything stopping us, even though it's the other side, offering support for that person. So sending them details of advocacy services, or sending them details of other law firms who they might be able to contact, or pro bono organisations, and then putting them in touch with somebody who can deal with those issues for them as well.
Yeah, I think that's. I'm not a contentious lawyer, but I think that's a really interesting question and an interesting response. There's some that have come in on the Q&A, and if you do have any questions for those that are still here, please send them through. We'll try and get to them. One has just come in. I don't know if you can see the Q&As. Perhaps there's one there that you want to answer, or maybe the bottom one there.
So I will just do the bottom one first because it's the quickest. Could you explain the issue regarding adverse cost implications for litigation friends? And I think this is really important to be aware of. First of all, you have to think about what are the costs provisions in the jurisdiction you're in, because you're in the family court or the court of protection, for example, or a mental health tribunal. The cost rules are different. But if you're in the type of litigation where adverse cost orders be made, so person injury, judicial review, that litigation friend needs to be aware. So when they sign their certificate of liability, suitability, that they are also signing that they will become responsible for making sure that that person discharges their liability for costs. So it's really, really important that advice is given to the litigation friend about liability for costs and that they understand that. Now, if somebody is eligible for legal aid, it's generally accepted that that provides them with a level of protection, which would then transfer to the litigation friend as well. But I mean, I don't want to go into this in too much detail because it's such an important area that I want to be able to do it justice, but you're completely right in flagging it and making sure that you're advising litigation friends on that. It might be that if the slides are being circulated to attendees after the event, I can just add a link to some guidance on that, which might be helpful for people, so you can read that with a bit more time.
Yeah, I think that sounds great, and I'm sure we can definitely look at something there.
Yeah.
Some of the other questions are quite lengthy in terms of.
There was one question about other jurisdictions, so for example, immigration. So what I would say about that is that there are many jurisdictions which don't yet kind of recognise this concept of lack of capacity and litigation friend, and don't have a neat system within which to deal with it. I think it depends on the particular case. For immigration, though, there is a really good best practice guide to asylum and human rights appeals, which has been prepared by Doughty Street Chambers and Public Law Project, about taking instructions, vulnerability and capacity in the context of immigration advice. And so I don't know whether I can put that in the chat. Let me see if I can do this.
We can always circulate it afterwards, perhaps.
I will type an answer. I'm going to put it in the answer to the question, so you can see, and then maybe Tabitha, if we could circulate that afterwards. That's a really good guidance for immigration context for all of this. The other thing to say is in respect of parole boards. Previously, there was no mechanism for individuals in the criminal justice system who were before parole board who lack capacity to be represented. There is going to be some guidance coming out on that shortly as well. So we're slowly catching up with these different jurisdictions that don't have provisions, but it does depend on the particular jurisdiction that you're in, what the answer to that question is. Thanks,
Polly. I think we might wrap things up there. I'm conscious that you might need some lunch, and indeed anyone watching who hasn't eaten might. But thank you. That was a really insightful webinar, and I hope those that are still here found it enjoyable and informative, because I certainly did. As I said, with the Law Society, if you do want to look at any other webinars, please check them out. But for now, thank you for everybody for attending, and we hope to see you soon. So thank you, everybody.
Thank you.
Bye-bye.
Bye-bye.